International law. International law harkens back to some of our initial subjects there in regards to where does the law come from? Well, the law comes from some type of sovereign, some entity above us who is delegating down these laws, and this entity we respect enough to obey those laws out of fear of repercussion or civil duty or some type of respect that we have for this sovereign. That's an important concept of international law is sovereignty. Some concepts of sovereignty would be self-determination, failed states, and failing states. We're also going to talk about sources of international law, which is interesting. Previously, almost all our realms of topic came from federal law or state statutory law or common law,
hey, Dad,
international law. Hey, what's up, dude?
I'm Link.
You're Link. Nice.
On that.
On Smash Bros?
Yeah, I'm Link.
Sources of international law include treaties, conventions, and customary international law, which really a bit deviates from what we're accustomed to in previous chapters. Also, how are disputes settled between parties from different nation states? Nation state against nation state, sovereignty versus sovereignty, or different international companies, or different international private citizens, or any mixture of those three trying to resolve some dispute amongst one another. Also, what are some well-recognized bases for national jurisdiction from various parties in different nation states? And also, what are some common doctrines, which would be common, I would call it almost common law in regards to international law, such as forum non-conveniens, sovereign immunity, and active state. We'll be talking about all of those in turn. In international law, the term nation state refers to what? That's important. As far as our textbook is concerned, a nation state is this sovereign authority that, again, the citizens are going to listen to. It's the entire sovereign nation. So it's not individual states. It's not provinces. It's not territories. None of those things. It's the sovereign country itself. That's what we're referring to. We're talking about nation state in regards to this chapter. Concepts of sovereignty. We've been talking about concepts of sovereignty here. Sovereignty has sovereign authority over a population of citizens within a given geographical territory in theory. And in theory, nation states should not interfere with one another's legal and political matters within borders of other nation states. That is a concept of sovereignty. I'm the sovereign over my area. You're the sovereign over your little area. We don't mess with one another in regards to the things we're doing inside of our own nation states. Historically, it was understood that nations had a right to issue their own currency, make and enforce laws without interference, and the right to have a military force. Those are common things that a nation state can do. How do we identify a failing nation state? That is going to be a combination of lack of control over its citizens, failure to provide public services, widespread corruption and criminality, and sharp economic decline are all attributes of a failing nation state. A nation state has the authority to do what? It has the authority to do all of these things. D is going to be correct. Defend its territories, military force, and to issue currency. The ability of a nation state to create and enforce its laws is a fundamental matter of sovereignty. Which of the following is a nation state? That would be Brazil. Sovereignty includes a nation state's independent authority and right of self-control. So far we've been talking about the fact sovereign countries can do essentially whatever they wish inside their own borders, and the other sovereign authority is not going to mess with them. They do have their right to self-control. They can limit their ability to do things inside their own sovereign borders, perhaps based off of some treaty or negotiation they had with another nation state. But you have the sovereignty has its own independent authority and its own right of self-control. Self-determination. Self-determination is the legal terminology we apply to the fact that nation states have all of these freedoms to act without consulting. So they have the freedom to act without being influenced or obligated to discuss with other nation states. They can go ahead, issue currency, form their military, create their laws, and that is their own business. Stay out of my beeswax, other nation states. That's the idea of self-determination. All of the following are signs of a falling nation state except for what? And that is providing. That's B there, providing public services. Remember, a failing nation state would not be providing public services. That's a symbol of failing. Sources of international law. So where does international law come from? Because nation states can do what they want, like Cartman on South Park. How do you come up with common law, or what are our sources of law? And it's sort of nebulous. It is whatever kind of works at the time for whatever tribunal happens to somehow have authority over nation states, which, as I'm saying this, kind of makes some sense. When is the United States going to opt to listen to some international court that's over here, something like that? They'd have to bow down, they'd have to agree to it, and then they'd have to agree to the result. And that's part of the problem with where do we come up with international law? And if the United States is going to agree to be part of some other court that's not inside their country, what laws are going to be allowed to use, right? Like you pick a law, it sort of picks the outcome, right? So you can see how difficult this is. But what are some sources? Sources that could be used to help resolve some international disputes in some type of international court can be treaties, conventions, which is just treaties is a one-on-one. That is one country, one sovereignty, one nation state. Well, I should use the terminology nation state here. One nation state coming with a contract between themselves. That's a treaty. A convention is going to be more of a regional thing. That's going to be multiple nation states. That's what you're looking for there, is the difference between a treaty and a convention. It's just the number of agreeing nation states. Otherwise, it's going to look the same. It's a treaty, it's a convention, it's a contract between these nation states. Two nation states, it's a treaty. More than two nation states, it's a convention. Also, customs. Sometimes nation states are just going to treat each other or do a certain thing a certain way. That custom potentially could be a source of guidance in providing a solution to a dispute. General principles of law. You could look at common law that has evolved over the ages that might be similar in Britain that it is into the US, that type of thing. You might find some commonalities there. Also, you can look at judicial teachings, decisions, philosophers might have written on the subject, and the International Court might look to that for guidance. We have this thing called the International Court of Justice. The International Court of Justice hears lawsuits between nation states. Now, the jurisdiction is not compulsory. Nation states don't have to listen to them, but the nation states can agree to allow the ICJ to hear the dispute. And of course, once they issue the order, again, the nation state has to decide to allow that order to apply to them or not, which is interesting. International disputes include arguments between what? Remember, it's nations, different companies, different individuals that reside in different nation states. All three of those types of things can be involved in international disputes. Treaties. Treaty is nothing more than an agreement between two sovereign nations. It's a contract, right, between two sovereign nations. A convention is going to be more of a regional or global. You're looking at more than two. Bilateral investment treaties are focused on commerce and investment. In the United States, it's 2/3 Senate vote to ratify a treaty. After a nation state has joined an international agreement, the nation state what? They withdraw from the agreement under the principles of sovereignty and self-determination. Even after the agreement has been made, the sovereignty has to itself decide the right of self-control to continue to comply with the treaty. At any point under the principles of sovereignty and self-determination can just breach their treaty. Now, of course, that doesn't mean that the other side has to be happy with what they did, or other nation states in the region need to be happy that they breached their agreement, but that doesn't mean they can't breach. Custom. Remember, custom still a source of law. How two nation states are treating one another, or how this diplomatic correspondence occurs, can be a guidance in regards to how a dispute should be resolved between nation states. Also, you can use this customary general principles of law. A good example is In re Bremen out of the U.S. court. So there was a disagreement, there was a contract essentially that was broken between a U.S. company and a German company. It's a big deal where the lawsuit takes place. If the lawsuit occurs in Germany as the forum of the lawsuit, well, the United States, that company has to send representatives over there, have to the whole lawsuit has to go over there. Likely their attorneys that they're accustomed to probably aren't fluent in German. The company itself probably not fluent in German, so they're going to have translators. They're going to have to hire a German attorney. That's costly, right? And the same for the German company if the lawsuit has to occur in the United States. So there you've got a really big problem. And then two, you might have a forum where you might feel that you have. So, this contract that was broken had what's called a forum selection clause. Inside the contract, it said if a dispute arises regarding this contract, the parties agree that the dispute will be heard in a certain place. Here, it happened to be inside the United States was the forum selected. So you had a German company and a U.S. company signing a contract, and the contract said if there's a dispute, the dispute will be heard in the U.S. The U.S. Supreme Court said that yes, we will hear this dispute because this clause in the contract says that these parties are to have this dispute resolved here, and they said that they hoped that a German court would do the same thing, that if the forum selection clause said the dispute will be heard in Germany, a German court would hold it because that's what the party selected to when they had the contract. So this was really nice in determining which forum the case should be held in, the United States or Germany. But not only will the case be held there, remember the U.S. court will then issue an order, and the order might say, well, sorry, German company, you breached the contract. You owe this U.S. company $5 million. Well, if the U.S. company wants to collect, likely they're going to have to take that order and then go over to Germany, file that in some German court and say, hey, this company owes us $5 million, seize some assets, give them to us, and that will be resolving our order because the German company may not just hand over the $5 million, right? You need some place where you can enforce it. And of course, the German court might say, hey, why are we going to listen to a U.S. court? Well, what the U.S. Supreme Court was saying was German court, if you issue an order, our U.S. courts will obey that order if the forum selection clause said Germany. And they said since this forum selection clause said the U.S., they were saying, please, let's allow the selection that the parties agreed to in the U.S. work for solving this agreement. Now, they can't bind, the U.S. Supreme Court can't bind the German courts, but the German court can say, yeah, as a general principle of law, that's a sound decision. We're going to go ahead and do that. So this is a great example of international law being developed via a custom of acceptance. And the more courts that begin to accept that logic, that legal logic, that then adopt that custom, the more it becomes kind of an adopted international law. The courts aren't forced to do it. Who knows what the court in Brazil would do, or Peru, or some other nation. Maybe they would follow this, maybe they wouldn't, but it is a great form of guidance. Judicial decisions in international tribunals, scholarly teachings. Okay, so we have this International Court of Justice. They might issue an order resolving a dispute between two nations. That could be considered common law, that then if a similar dispute would come up, you would look back to that previous case and you'd say, yeah, that previous case is binding upon us or precedent or whatever, so we're going to follow that. That doesn't happen so much in the international court realm. It can be guidance, not necessarily binding, and of course, too, they can look at scholarly writings if they would like in order to guide their decision. All right, the purpose of the International Criminal Court, I think that was in a slide above, but I missed it. The International Criminal Court is there to prosecute big war crimes that a nation state does, like genocide, that type of thing. That is the purpose of International Criminal Court, is to prosecute big war crimes that a nation state did. Or I should say the sovereignty of the nation state did. Regarding the International Criminal Court and the International Court of Justice, remember the International Court punishes people for crimes such as genocide, and the International Court of Justice settles arguments between nations. The International Court of Justice hears lawsuits between nations, can also hear, it's only between nations, and the nations have to agree to hear the dispute there. It's A. Due process and recognition of foreign judgments. I talked about this for a moment before, like why would the German court pay any attention to the U.S. court order, and why, and vice versa. If someone from Germany comes over and is like, hey, I've got this award from a German court ordering Professor Crane to give me $1 million, the U.S. courts can be like, well, do I have to listen to this? Do I need to make a U.S. citizen fulfill this German order? Like, was due process had? Was there fairness, etc.? That's one of the reasons why courts would be suspicious of just granting any old international order from some other nation state. They're going to be concerned with fairness and procedures and due process. So a U.S. court might say, well, was there due process? They might look at the German court and say, did Dan get service? Oh, he got service. He had notice that he was being sued. Great. All right. How long did he have to respond? Oh, 28 days. That's just like in the U.S. Well, that's great. That's fair. And they might compare for fairness with how it works in the U.S. and due process is qualified. And they might say, hey, does this other nation state do it similarly? And therefore, we should go ahead and respect this order from this other court and then go ahead and follow through with the wishes of that other court, which whatever result of the order is fulfilling that. Arbitration. We talked about forum selection clauses in contracts. It's a good idea in an international contract to have a forum selection clause. That way, if I am dealing with a company in France and we might potentially have a dispute, there should be a forum selected in our contract, whether it's the U.S., whether it's France. We can pick anywhere we want. We can pick Ireland. If the two parties agree, whatever, that gives us a point where we're going to file for our case. It gives us someplace to go, at least. Arbitration is similar. If we put on there that our case is going to be arbitrated by some arbitration company in New York, well, that is also going to be binding upon those parties and is going to give them an area they can go to resolve their dispute. Basis for national jurisdiction under international law. A nation state has jurisdiction to make and enforce laws within its own borders and with respect to its citizens wherever they might be. If I leave the United States, I'm a United States citizen, the United States laws still apply to me even while I'm out of the country with respect to actions taking place outside of their territory but affects the territory, right? So the action can take place outside the U.S., but U.S. laws could still apply if the actions are having a direct impact upon the nation state of the United States. Once jurisdiction is established, right, that then gives the court jurisdiction. So if I'm a United States citizen, I leave the U.S. and I break some sort of U.S. law, the United States can have jurisdiction over that law breaking. Now, maybe the other country would too under their own claims, and I might be facing criminal charges in, let's say, France and in the United States at the same time, but the United States courts will have jurisdiction over their own laws for whatever I broke regards to the United States law. All right, some exceptions here would be forum non conveniens, sovereign immunity, and active state. Forum non conveniens is where this dispute is occurring might not be convenient for me, and so it can be difficult to pick the forum where the thing should occur. So in the example before, we had this German company and this U.S. company who had a dispute. Well, there happened to be a forum selection clause saying it should happen in the United States. The forum of the lawsuit is in this U.S. court. If there's no forum selection clause in there, it's way harder to figure out which court has authority. Potentially, the German company files in Germany, the United States company files in the United States, and then you've got a big mess. Which forum is proper? Well, you're going to have to figure that out. One forum is going to be non-convenient, forum non-conveniens. That court is going to dismiss the case and not have jurisdiction, and the other court will keep the case and have jurisdiction. Who knows which one that'll be? Going to be difficult to decide, but it is an important aspect to know in regards to international law. The other thing is sovereign immunity. Regular people and companies often cannot sue a country. Now, in the United States, we might be accustomed to being able to sue the United States or our government for certain things, such as if Ohio, the state of Ohio, decides to take over my house and put a highway right through my house and kick me out of my property, well, I'm going to be expecting what? Some compensation, and that's what happens in the United States. And if Ohio was doing that to me and did not, come up with an agreement and send me a check for buying my house, well, then I'm going to be suing Ohio, right? And I'm going to be able to get around the sovereign immunity of the state as the government actor. Also, we have the active state doctrine, which talks about active states. The state is allowed to do certain things. Typically, the state can act in a government type of role and have sovereign immunity, but as soon as a state begins to act like a business and partake in the realm of a business selling sandwiches or something like that, they are going to be able to be sued just like any other sandwich company. So if McDonald's manufactures something in a poor way, a cup or something, and I injure myself on the cup, and they were at fault, they really should have manufactured the cup better, I can sue them, right? Correct, I can. If the United States decides to manufacture a cup and go into the selling of cheeseburgers, french fries, and Pepsi drink, and they will be as suable as McDonald's is. They won't have any kind of sovereign immunity for their actions while they're acting in a business-like manner rather than in a governmental manner. An established principle of international law includes what's up, dude?
Guess what? So it was on time seeing if you get knocked up in the sky, and guess what?
Hey, what?
I was on 3 players this time. And guess
Yeah.
what?
Hey, what?
One of them knocked one of the players, not me,
Yeah.
into the sky. And
Oh, my
then
gosh.
I was right behind her,
Yeah.
Mario. And then I went to her.
Yeah.
While I was behind her back, and then
Yeah.
I slid on her.
Yeah.
And then her got backing up the race too.
Nice. High five,
Then
dude.
it was me who won.
Nice. Then you
And
won.
they couldn't even know I was back up.
Way to
And
go.
I just, okay, I go for the state. Woo!
Nice.
When I was like,
Nice, dude. An established principle of international law includes what? Sovereign immunity and enforcement of forum selection clause. Those would be established principles. Those would be guiding principles of international law, sovereign immunity and enforcement of forum selection clauses. We've talked about forum nonconvenience enough and forum selection clauses. They work. You should do them. It is difficult for an individual to enforce one nation state's judicial judgment in another nation state because, we've talked about that at length, a nation state has jurisdiction over what? This could be tricky. Remember, it's anything that happens inside their borders, anything a citizen does, wherever they might be, and also actions taking place outside of their borders but have direct impact beside their borders as well. So there, D is the correct answer. It's all the above. A forum selection clause in an actual contract may require all kinds of stuff. It could require an arbitrator, could require disputes held here, all this kind of stuff. All those things would be possible in regards to selecting how a dispute will be resolved inside of a contract. If the losing party from one nation state refuses to pay an arbitration award to the party from another nation state, the winning party must petition a court somewhere to enforce it. The result will likely be that it will be upheld. And then, I didn't mention this before, but the New York Convention was a convention of nation states all coming together to create an agreement, i.e. like a treaty. Remember, it's called a convention when it's a region or multiple nation states. Agreed that yes, hey, if there's a forum selection clause or arbitration clause, we really should pay attention and do what it says. It just makes it way easier for our court systems to decide the proper forum when the parties agreed to it from the outset. They went into it with their eyes wide open in the original contract. The court in one nation state may have difficulty enforcing the judgment of another nation state. Why? And that's because of all these reasons: fairness, due process, also the type of damages awarded. In the United States, we don't have jail time for the breaching of a contract. Let's say that's a civil disagreement. You might have damages of some sort, but you're not going to have jail time. If another country had a breaching of a contract and then you're in jail for a year and you bring that to the United States is going to say, heck no, we don't do that here. Breaching a contract is not jail time for a year. One nation state's enforcement of another nation state's judicial order will require what? And it would be the third answer there, C, reciprocal treaties like the New York Convention, saying that, yeah, we're going to allow this, or also checking that the order was fair. Remember, the United States gets an order, right? Any nation can do this, but you get an order from another nation state. You can look at that judicial court's order and say, was this fairly obtained? Was it due process similar to the United States? And what kind of damages are on here? Yeah, that's similar enough. The United States will go ahead and enforce this foreign nation's judicial system's order, or you might look at it and say, no, this is not fair under due process, etc., and then not enforce the order. The United States has agreed to give up some of its sovereignty. Remember, sovereignty has self-determination, right? Sovereign can do whatever they want, like Carmen on South Park, but you can give up some of your sovereignty by agreeing to a convention, treaty, or treaty, and give up some of your rights in order to usually obtain something or agree to something. And the United States gave up some of its sovereignty to join NAFTA. To avoid a conflict of jurisdiction when the parties live in different nation states, a contract should include some type of dispute resolution forum, whether it's arbitration or forum selection clause. Forum nonconvenience is a legal doctrine whereby, remember, forum not convenient for me, it's trying to figure out which court should have jurisdiction over the parties, what is the appropriate forum. When a tort takes place between parties that live in different nation states, remember, a tort is not a contract, so you wouldn't have a forum selection clause. There's no contract, no forum selection clause. Instead, the courts must rely on what to determine which court will hear the case, and that's forum nonconvenience. Forum nonconvenience means it's not convenient for me, but it's got to be convenient somewhere, so they're going to look to forum nonconvenience to try to decide where this would occur. An example of this I gave in class was, let's say I really like Indian food, which I do. I travel to India to have a vacation there and try out all different kinds of food. As I'm walking around through India, someone decides they don't like the look of my face, and they run over and they punch me in my face. I always love getting punched in my face in my examples. That would be in a battery that has occurred in India, which is a tort. And if I wanted to sue the person who punched me in the face, where would I sue them? There's no forum selection clause, so I don't know. It would either be in India or it would be in the United States. I'm betting you I'd have to sue them in India, even though that forum is really not that convenient for me. The judicial doctrine that is used to determine the proper forum where the courts of two different nation states can claim jurisdiction is called what? Forum non conveniens. Sovereign immunity. Sovereigns, the king enjoys complete immunity for their actions, for their own acts. That's been for a long time, but that's eroded away. There are some acts now that they can be sued for. Sovereign immunity is legal doctrine by which a nation state is immune from civil action, criminal action, international law, all that kind of stuff. All those things are sovereign immunity. Sovereigns have the right of self-determination. They do what they want. Under the doctrine of sovereign immunity, some nation states distinguish between a state act government and a commercial act committed by a state-owned company. Remember, when the government's acting like a company, they are going to lose their sovereign immunity, is the typical thing. Like, remember, this is giving up of their rights, but like the United States, this is how the United States would do it. They're going to have less immunity when they're acting like a business. International law includes what? Where do we get our sources of law? We get it from treaties, conventions, customs, general principles of law, and judicial decisions. All those things can help guide international law. Act of the state. Good one of that is taking a citizen's property. The United States, an act of state would be taking a person's property. We have the Fifth Amendment, says you need to justly compensate for the property so taken. Also, U.S. courts will reject private claims based on acts of state from other nation states. So if I have, let's say, a house in let's go with Ireland. Let's say I've got a house in Ireland. Got my vacation house in Ireland, and Ireland does an act of state and takes over my little personal property I have in Ireland, takes it away from me, and doesn't justly compensate me. I can go ahead and sue in Ireland if I want, and they may or may not have some type of just compensation. I would assume that they do, but I cannot sue Ireland in the U.S. court saying it was a taking and asking the United States court to do something to Ireland or requiring Ireland to justly compensate me. Does not happen. They're going to reject that claim because that was an act of the Ireland state. In the U.S., expropriation, taking the private property, cannot occur unless the owner is justly compensated. I'll let you read through this and decide based off what we just discussed there. The legal doctrine, and I'll let you read this one here again too. Remember, nation state 1 and nation state 2. This is just a way to separate two different nation states. A nation state will not sit in respect to another nation state's action, i.e. my vacation home being taken in Ireland. A United States court will not sit in and issue something to Ireland. Why not? It's an act of state doctrine. It's Ireland's act of state. They're not going to be doing anything about Ireland taking the property away. I have to sue in Ireland in an Irish court. Act of state is a legal doctrine by which it's very similar to the other one we went through. Go ahead and go through there, pick out the right one. Regulating trade. Remember, self-determination, sovereignties can do whatever they want, but they can restrict some things and come up with some agreements to make some changes. So typically nation states wish to protect their domestic industries through the use of taxes, tariffs, also called duties. What do they protect themselves with? Their domestic industries, taxes, tariffs, and duties. They would charge incoming property taxes, right, that's coming into their nation. Although some believe that free trade is better, one of those entities is the General Agreement on Tariffs and Trade, the GATT. They are enforced through this World Trade Organization. Anyways, the GATT and the WTO would like to reduce tariffs. So when you're thinking of General Agreement on Tariffs, think reducing tariffs. Arms of export control and the Emergency International Economic Powers Act gives the president considerable powers to impose limitations on trade for, typically you're looking at controlled goods, military weaponries, exportations thereof. Limitations on tariffs. Free trade proponents say the tariffs are bad. Opponents of that say, hey, it allows outsourcing when you don't have tariffs. The United States joined the North American Free Trade Agreement, NAFTA, and then you'd have free trade says, yay, that's good. Opponents say, no, that's bad. Remember, those are the two opinions. The NAFTA, etc. NAFTA is the United States region with Canada. Similar one is called the European Union. That's for the EU, the France, etc. Italy have this standard for reducing tariffs, subsidies, transportation, human rights, and other issues as part of this European Union. This would be like a convention. It's like a treaty, but multiple, so it's convention. Another regional trade agreement would be the Mercosur. It's an organization formed by Brazil, Argentina, Uruguay, Paraguay to improve trade and commerce through those. Now, what they try to do is reduce trade barriers. The Mercosur specifically reduces trade barriers, reducing tariffs, eliminating tariffs, and they also have a social agenda focusing on education, culture, the environment, consumer protection. All of those would be having goals they have, in regards to having a better environment, consumer protection, etc. laws they're going to do, and their self-control they're going to implement upon their sovereignty. An agreement on a matter of common concern negotiated on a regional or global basis and often adopted by many nations is called a what? It's a convention. This might sound like a treaty, but remember, once you do regional or global, it becomes a convention. A convention is generally, it's a matter of common concern. It's negotiated on a regional basis. Sometimes it's sponsored by an international organization. It's all those things. D is correct. An agreement between two sovereign nations, it's going to sound a lot like a convention, except it's just two, so it's a treaty. In the United States, a treaty requires 2/3 vote by the Senate. A bilateral investment treaty focuses on commerce and investments. A custom between nations is different from most international agreements because a custom is just based upon consistent recurring practice for a significant period of time. Nations recognize it as a binding principle. The general principle of law is different than a statute because it's just it's a guiding principle. The courts may follow it over time, in the middle of custom, that kind of thing. It's a general principle, has no effect really on international law until it becomes a statute. All of those things are true. Taxes on imports, remember taxes are taxes, tariffs, import duties, etc. All three of those things. The United States taxes imports from other countries. That's true, A. The United States controls certain exports that may do what? It would be all of those things. The purpose of the U.S. International Economic Powers Act is it gives the U.S. President power to impose sanctions to limit ability on trade. The primary purpose of the General Agreement on Tariffs and Trade, the GATT, remember, is to decrease tariffs that hinder the free flow of commerce between nation states. Which of the following is our regional trade agreements? It's going to be all of these. The NAFTA, the EU, and the Mercosur, however you say that, regional trade agreements are, remember, they're praised and they're criticized. They're praised because it increases global trade and well-being, but it's also criticized as potentially creating domestic decline and outsourcing. The EU does all of those things. The Mercosur also as a D does all of those things. And we've reached the end. Well done. This is our final chapter for our business law class. Thank you everyone for all your hard effort sticking in there. I know a lot of these items you've probably never dealt with before and are brand new knowledge and information for you. Hopefully it's broadened you as a person and has given you some information that will be applicable in your own life moving forward in regards to how you yourself deal with contracts and how you better understand the things going on in the world around you. Professor Crane signing off.